Hey, everybody coming in. So, tonight we are going to be watching Eisenstadt v. Baird. Not as well known as Griswold v. Connecticut. However, this case built on precedent set in Griswold. So, Griswold v. Connecticut talked about. Sorry, I'm trying to find the words right now. Talked about the right to privacy and married couples being able to choose whether or not they want to have a baby. They talk in use of contraception. Now, Eisenstadt builds on that precedent. It builds on the precedent that is set in Griswold for privacy. And it says, well, I mean, if married people can do it, why the hell shouldn't single people also be able to do it? So again, we're watching Eisenstadt v. Baird tonight. While this is not quintessentially a landmark case, it's so important because Griswold v. Connecticut, which we watched on Monday, only affects married people. Eisenstadt was the case that said, hey, if married couples have this right to privacy and use of contraception, why the hell don't single people? So I'll read a little bit of background on it and then we will get into the oral argument on it. So the facts of the case are that William Baird gave away MCO smaginal foam. Sorry, I'm trying not to get banned. To a woman following his Boston University lecture on birth control and overpopulation. Massachusetts charged Baird with a felony to distribute contraceptives to unmarried men or women. Under the law, only married couples could obtain contraceptives. Only registered doctors or pharmacists could provide them. Baird was not an authorized distributor of contraceptions. And the question became, did the Massachusetts law violate the right to privacy acknowledged in Griswold? Like I told y'all, we're building on precedent here, and protected from state intrusion by the 14th Amendment. So we are going to hit the oral argument, and this one isn't long, and then we'll actually have a conversation about both cases. So without further ado, this is Eisenstadt v. Baird.
We'll hear arguments in number 17, Eisenstadt against Baird.
And hi, everybody coming in. Sorry, these older ones take a minute.
Nolan.
Mr. Chief Justice, may it please the court. This case comes to this court on an appeal from the First Circuit Court of Appeals. This court noted probable jurisdiction on March 1st of 1971. The case started factually on April 6th of 1967 when the appellee, Mr. Baird, addressed a group of people, mostly students at Boston University, pursuant to an invitation. Approximately 2,000 people were in attendance. At that time, Mr. Baird used two particular demonstration boards in his lecture on contraception. These demonstration boards had various contraceptive devices, and alongside the lectern there was a carton box filled with various other contraceptive devices. After the lecture, he invited the people to come to the lectern and in grab bag fashion take what they wished from this carton. He then, I repeat, it was after the lecture, he then handed a can of MCO, an admittedly contraceptive device, to a young lady. Now, I do want to bring to the court's attention an inaccuracy in the appellant's brief in the reference made to this young lady as being unmarried. The record does not indicate, nor did the Commonwealth at this time introduce evidence tending to show that she was unmarried.
What page does that first appear on?
It is not significant, however, to the case.
Page 4.
Page 4 in the statement of the case,
right.
Mr. Chief Justice. It is not, however, significant to the case, but I do want to point out the inaccuracy, and the correction made by Mr. Bolero in his brief, the original brief, is well taken. Repeatedly during the lecture, the appellee, Mr. Baird, invited the police to arrest him. He said, "Why don't you arrest me, officers? I am violating your Massachusetts law." Finally, when he handed this can of MCO to this particular young lady, the police complied with his wishes. Now, the appellee was charged in 2 indictments returned by the Suffolk County Grand Jury.
So I want to point this out too. So we have kind of an understanding of what the dates are here. In 1965, they argued Griswold, which dealt with married people being able to have the privacy to make their own decisions on, maybe whether or not they wanted to have a baby or another baby. Birth control was extremely limited. And then this decision on single people and the right to privacy is, sort of noted in Griswold, extends to single people. So, yeah.
The violation of Massachusetts General Laws, Chapter 272, Section 21, which, among other things, prohibits the giving away and the exhibition of, to use the words of the statute, articles intended for the prevention of conception. After the trial in Suffolk Superior Court, jury waived, he was found guilty, and the trial judge reported the case to the Supreme Judicial Court. One indictment charged the defendant with exhibiting contraceptive devices in violation of the statute, and the other charged him with the giving away.
Imagine a time where you can't even advertise birth control.
Lending and so forth. 2 words that are important are exhibiting and giving away. The Supreme Judicial Court reversed the conviction of Baird under the indictment charging him with exhibiting because, in its opinion, it clearly violated his First Amendment rights, particularly the freedom of speech right. However, by a divided court, it sustained the conviction under the indictment charging the giving away of the can of MCO.
Would there have been any difference in the case, Mr. Nolan, if Mr. Baird had been a licensed physician?
Yes, because I was going to call to the court's attention in a moment that both statutes on pages 2 and 3 should be read together. Chapter 272, Section 20, which is the prohibition statute, and Chapter 272, Section...
Well, maybe I didn't read this very carefully. 21A says a registered physician may administer to or prescribe for any married person drugs or articles.
Yes.
If Mr. Baird were a licensed physician, he was not at the time.
He was not, no. Admittedly, he was not a physician.
Well, if he were, suppose Mr. Baird were a physician and
Yes.
were doing exactly as he did here, would he still be prosecuted under this statute?
If this were a girl, and it would be at this point only that it would be significant as to whether she was married, he would not be prosecuted, certainly if she were a married woman.
My question goes a little more deeply.
Max, does it have anything to do with this case? I need you to let me know in the comments.
He was administering to her and prescribing for her
In
a
giving it,
professional
yes, I do.
capacity, even though he was giving a lecture to a group of 2,000?
Yes, because while many helped themselves, in this particular instance, he gave this girl the MCO. I don't suppose it would be, I think it would be silly of me to say that he was administering to in the way a doctor would in handing it to her.
Well, it
I'm not
certainly
suggesting that.
is a different situation.
Yeah, Max, shoot me a
Normally,
DM. I'm happy to answer it. Just we're going to stay on this one for tonight.
The trial court then sentenced the defendant to 3 months in house correction, stayed that sentence pending appeal to the Supreme Judicial Court, and a further stay was granted while a petition for certiorari was addressed to this court to the Supreme Judicial Court, and that was denied. And Mr. Baird then started serving his 3 months, and I believe he served 34 or 35 days of that.
Who else would I be?
The Circuit Court of Appeals, and I'm getting ahead of myself, in addressing itself to a petition for writ of habeas corpus to the District Court, and the District Court, I might say, denied the petition for the writ. The Circuit Court of Appeals for the First Circuit issued a certificate of probable cause and released the appellee on bail. He served, I believe, 34 or 35 days of his sentence. This case, then, is in the posture of an appeal directly from that order of the First Circuit. And I would add that in both cases, the district court judge filed an opinion, which you'll find in the appendix, and the
Bougie. Oh my God, let me send you a
Now, there are two
DM.
questions
The
that I
case
think
that we covered
are addressed to this
Monday,
court, and the first is
eerie
whether the
shit.
Massachusetts statute, and when I say statute, of course, I must include a reading together of the two, whether or not the Massachusetts statute prohibiting it.
Okay, so if a couple of people, like, I know there's a few more people in here now. I kind of did this at the beginning, but I'll just pause briefly and we'll get right back into it. So there is a case, if you're unfamiliar with it, called Griswold v. Connecticut, which not only really kind of not, I wouldn't say it established the right to privacy, but it certainly like made it very apparent, right? And this is in regard to contraception and married couples. This case happened back in 1965. Now in 1972, hi Law, you're welcome to come up whenever. So now in 1972, we are looking at Eisenstadt v. Baird, which isn't necessarily a landmark case, but it does build on precedent set in Griswold. And that's why these two cases are so important. But in Eisenstadt, we're looking at, hey, if married couples have this right to privacy and the ability to make contraceptive choices for themselves, why the hell don't single people have that same choice? So that's what we're looking at right now. And again, Law, you're welcome whenever. I figure you're doing chicken
away
stuff.
Of an admittedly contraceptive substance, whether or not that is constitutional. And secondly, whether or not the Massachusetts statute is unconstitutional as applied to William Baird, who was admittedly a married man and who was admittedly also not a physician nor a nurse nor a registered pharmacist or clearly not a public health agency. I would like to address myself to the second question first, and that is the question of whether or not William Baird has standing to raise this question. Now, he is admittedly a married man. He is in effect asking this court, even a cursory reading of his brief I think indicates this, he's asking this court to declare unconstitutional this statute as it applies to others, because clearly his constitutional rights are not invaded.
But he's challenging the conviction.
Yes, he is, but I don't believe it.
I should think he's got the... Could he possibly have a greater interest?
Well, it's my understanding that merely because he was in jail does not give him tailor-made standing as we're using it.
I thought he filed a petition for federal habeas corpus challenging the constitutionality of his detention by Massachusetts on the ground that the underlying statute is unconstitutional.
Yes.
And you're suggesting he doesn't have standing to do that?
I'm suggesting that he does not have standing as we know standing simply because he was convicted of the statute. Now, perhaps, Mr. Justice Brennan, you're saying to me, well,
challenge on standing.
Anytime there's a First Amendment problem here, he doesn't have to have the kind of standing but I'm a little ahead of myself, but I don't believe that he has First Amendment standing. I'm talking First Amendment rights here. I think...
I'm going to throw in a little side note on this. So this case was brought by a gentleman who I believe he was convicted on the distributing of these contraceptives to unmarried persons, particularly a woman. However, there was another one that he was charged with. They ended up just being like, nah, is this his First Amendment right? What I find interesting, though, is here, a married man had to bring this case to get single women their rights. Let me ask you a really serious question, chat, and I really want you to ponder this while we're listening to this. And, everybody has their own opinions, and I'm cool. But tell me this would not have worked out differently had a young single woman brought this case. Oh, wait.
I don't see where his rights have been invaded. I don't see where his wife's rights have been invaded. Both of them can seek and receive contraceptive devices within the framework of the Massachusetts law. I think the language in the Raines case is clearly apposite here, where this court said that the rule that one to whom application of a statute is constitutional will not be heard to attack it because it's unconstitutional as applied to somebody else.
Yes, but he certainly has standing to say that my conviction here is unconstitutional because the statute,
that part,
which restricts the distribution of contraceptive devices to physicians, is unconstitutional. Massachusetts said he violated the law, among other things, because he wasn't a physician.
Yes.
And he says the law may not restrict the distribution of contraceptive devices to physicians. It's unconstitutional in that respect.
Well,
Certainly he's got standing to say that.
I would say he'd have standing there if as the basis for saying that, the right to be a physician or the accompanying right is a First Amendment right. But I don't see that...
First Amendment right? Well, I would think that if he said that Massachusetts could not, within the Due Process Clause, for example, restrict the distribution of contraceptives to physicians.
In answer to you, Mr. Just what I would say that he'd have no more standing. He has no more standing here than if he went to practice medicine, was arrested for the illegal practice of medicine, and then...
My little thing down here is like glitching out.
This court would say that he had standing. Because the practice of medicine is not a First Amendment right as such for a man who is obviously not a
I know,
doctor.
but the First Amendment isn't the only grounds on which a state statute can be unconstitutional.
Well, the other grounds that he's talking about, namely due process, I will take in a moment, but the due process that he's talking about is some right of privacy.
Mr. Nolan, suppose the Massachusetts had a statute that said that it was illegal for anyone to prescribe the use of or to hand to any person any quantity of wheat germ, for example, or some other innocuous substance, unless the person handing it or engaging in that act was a registered physician. And then he gives some wheat germ away and he's arrested.
It's kind of an interesting point.
I have no problem with that at all.
How is it different from this one in that respect?
Well, I'd say I think it's trenchantly different. May it please the court. I think it's trenchantly different because and I hope that the court will see from our brief that there are
just
some
for clarity,
very dangerous side
hold
lights
on.
and side
I always
effects
forget
of
I
the
can
use of
pause
many
these when they're not live. Just for clarity, at least from what I'm gathering, essentially what he handed this young lady that he was ultimately charged for is something akin to what we would commonly call today spermicide. That's what he gave her. That's what they're saying. He can't get, he's not a licensed physician. I mean, I think the understandings of it were different at the time. I could maybe run with it, but yeah.
And I think an examination, and I am ahead of myself, but I think an examination of the Senate Committee on Monopoly when the pill was being examined.
Well, now you're going to the merits, aren't you, rather than just the question of standing?
Well, I must needs go to the merits, I think, to answer your wheat germ example, that's all. I don't think that I don't think it's a good analogy.
Well, but
wheat germ, I think
his point of view, that's all I'm addressing my hypothetical. From his point of view, perhaps the situation of wheat germ is exactly the same.
Well, I think he may think so, but I don't believe that his thinking is...
Do we reach the merits of the validity of your position about the possible harmful effects on just the standing question?
No, I do not believe we do. No, I believe that has to be taken with respect to the constitutionality of the statute itself. But I do believe that there is a serious problem here in standing, because he himself and his wife are not prevented from the benefits of the Massachusetts statute in receiving contraceptives or in being prescribed contraceptives. There's no right of privacy involved here with him. This is not a Griswold situation. He keeps speaking about a right of privacy, for example. But it's not his right of privacy. I think the district court judge said that more eloquently than I did in his opinion. He said in effect, and I'm just paraphrasing, it's in the record, he said that we would hear Mr. Baird of his right of privacy, but he is asking you to hear him with respect to the right of privacy of the unmarried, for example. And I don't believe that he has standing to do that.
That's actually probably the strongest argument here, is the standing. I would have questions myself.
I think are interesting on page 5.
May I ask another thing? If I read the opinion, am I correct, of the Court of Appeals of the First Circuit, the First Amendment arguments were rejected as an attack on the merits of the constitutional question. And the court found that the statute was unconstitutional on quite different grounds. No rational relation to...
No reasonable relation to the exercise of police power.
If that's correct, what moment is it that we're urged again to turn this on First Amendment grounds. If the Court of Appeals was correct on the grounds it took, then it requires an affirmance.
I raised the First Amendment, Mr. Justice Brennan, only in response to the question of standing. This court has said that a person would have standing which he otherwise would not have.
Does he not have standing to assert the constitutional arguments that he did assert, on which he prevailed in the First Circuit?
Well, of course, the First Circuit found that he did have standing. This is, I suppose...
They rejected his First Amendment grounds, I suggest. If I read their opinion.
Yes, that's right. That's right.
They turned it on an entirely different constitutional infirmity as they saw it.
That's right.
And is there any suggestion on your part that he didn't have standing to raise these other constitutional contentions?
Yes, I'm stoutly contending that he doesn't have standing for the very reason that he does not have a First Amendment freedom or right involved here.
Oh, shit. He just said, fuck his shit.
Well, on page 8...
I do hope you're going to get to the grounds that the Court of Appeals did rely on in holding this statute.
Just in a moment, I will.
Dead ass.
He refers to abstinence, for example, on page 8. He says, is abstinence an adequate answer? He refers to maternal mortality on page 9, or infant mortality.
Yeah,
but it's not,
fuck
I repeat,
them
open
women.
to him. Again, he purports to be the voice of somebody else in this particular question. He's asking you to overrule or to strike the statute because the statute affects other people, not him.
So here's the question I'm asking myself. If he's the one that can be charged for violating this law where he distributed this to a single person, but that single person can't be charged under the law, then does he have standing? Like, I do have serious, I do hope law joins us after a while, because I want to probe the standing thing and the reasoning here so I understand how we got here, but I'm wondering if it's sort of like our Texas bounty laws or like our abortion laws can't actually charge the patient. You can't charge that person, but the people around them who contribute to it, they can be sued or charged or what the fuck ever. Like doctors can be charged and people can be sued. And I'm curious about this because this is now making my brain kind of work in overtime.
Health characteristics on page 10. The unwanted child, and so forth. I repeat, I think that he does not have, in the strictest sense, the standing that he should have here to raise these other related questions, whatever. And I'm not questioning the various findings and the...
But if the single person can't do it, because they weren't charged with... Well, I guess they could,
now,
but I don't know.
The first question, which is raised, namely the constitutionality of the statute itself. It prohibits, among other things, a person who's not a doctor, reading the statutes together, from giving away, and it prohibits...
Around the fucking time we let women have bank accounts, like, them bringing a lawsuit just seems like a stretch.
I think it's critically important at this juncture to examine what the issue is not. You are not being called upon, in this case, to determine whether or not a statute making it a crime to use a contraceptive would be unconstitutional, because use is certainly not prohibited. You're not being asked to rule on the wisdom of the legislature in prohibiting, because I suggest respectfully to you that's beyond the power of this court as to whether or not it's wise for the Massachusetts legislature to have it. You certainly will not sit as a super legislature to determine whether it's wise to do it. You're not being asked to determine whether or not contraception is per se evil or in violation of the natural law. Though it is interesting to note that certainly this statute was enacted in 1879, clearly a public morality statute, and while for the last few years there's been a solid attack on the question of the natural law and whether or not it's violated, there's still some few of us
soft
who believe
sits
that it's also
incoming, not
against the
natural
law. But that's
law.
not the issue. You're not being called upon to determine the intrinsic evil of contraception.
Was the statute first placed on the book in 1879?
1879, you're right, yes. You're not being called upon to decide whether the legislature of Massachusetts should improve the lot of the unmarried by allowing the untrammeled distribution of contraceptives. Mr. Mr. Black, Mr. Justice Black, speaking for this court in the Ferguson and Scruper case, said that courts do not substitute their social and economic beliefs for the judgment of legislative bodies who are elected to pass laws.
Well, I take it your argument is, in a way, that if a state wants to channel the distribution of a particular commodity through a certain group of licensed people, it may constitutionally do so.
Particularly where the commodity has a certain inherent potential for danger, yes.
For health.
Yes, sir.
But in terms of the due process clause, arguably a state could say that, we're going to take bread and we're going to give a monopoly to the distribution of bread to a certain group of people.
I don't suppose to do that, no. I'm not suggesting.
Well, I don't know. As far as the due process clause is concerned, it may not be able to do it in violation of the antitrust law. As far as due process is concerned.
Well, even with respect to due process, bread seems to be such a innocuous thing that
I know, but it doesn't. So you are saying then, if it is really innocuous, it would violate the due process clause. Is that it?
If it were bread or wheat germ, something like that, I don't know that I would
Just a side note, this case ends up sort of being settled on equal protection under the law.
I think the issue then is whether or not Massachusetts may, within the framework of the police power, enact a statute that I submit to you does more than just indirectly touch the public welfare, morals, safety, health of the community. Now, I think it's almost fatuous to say that there's no connection. A great deal of my brother's brief is given over to saying, I think the gist of it, it's always perilous, I suppose, to paraphrase your brother's argument, but I think the gist, one of the arguments is that the prohibition against the unmarried having this has absolutely nothing to do with public morality, nothing at all to do. Now, I would be the first to concede the lack of success that this statute has had with respect to what the founders or the legislature thought in 1879 and the language that was used in the Allison case for a solid moral citizenry. I am the first to admit that it has certainly not succeeded, but I do question whether or not the lack of success of a statute is any reason for declaring it unconstitutional. I think it's fatuous, I repeat, to say
he may be right, but that's just a terrible fucking
albeit
point.
Perhaps unsuccessful connection with public morality, not to mention public health.
So, I just want to clarify here. It's both a good and terrible point. Like, he's like, well, it really doesn't fucking do anything and we don't have much success with it, but we should fucking keep it anyway. He makes a point. It doesn't mean it's like unconstitutional or anything like that. Like, it doesn't. But it's still just, I don't know that I would have phrased it that way. I just don't know that I would have. But this is the 70s and half these people in this court are drunk. I'm going to be very real with you.
I think to say that to lift the ban, to say that because I can think of only a quick parallel, but I don't suppose anybody would seriously contend that because gambling goes on, illegal gambling goes on in 80% of the, let's say, variety stores or bar rooms in Massachusetts, that therefore the gambling statute is unconstitutional because it's not working out, or the anti-gambling statute. And I think the analogy is not too far from here. My brother has pointed out many social evils, all of which I think we're acquainted with. The unwanted child, the illegitimacy rate. Now, all of these things, as facts, of course, must go uncontroverted. I'm not suggesting that there's anything inaccurate in my brother's brief. I think, however, where he fails is in asking you to draw a nexus between the failure, for example, the high illegitimacy rate. Now, conspicuously absent from his brief is any study that would indicate that in jurisdictions where the legislature has seen fit to relax the law on contraception and permit a free distribution of contraceptives, that in those jurisdictions the illegitimacy rate is any better or any lower. Now that's significantly absentizing, and conspicuously so, from my brother's brief. He is putting forth these social
So it's not
evils,
any
all of which we
higher,
admit, I think,
but now it's a problem that it's not any lower.
with the ban that this Massachusetts statute has on the free distribution of contraceptives. The other argument that I think is important here is he keeps stressing the fact that nobody pays any attention to it anyway. And I've alluded to this moments ago, but I would say that I think it's important enough to repeat that can't be the measure of whether or not this statute is within the framework of the police power that Massachusetts has. It just cannot be.
He's
Now,
not
there is
wrong
one,
there. It's still
argument
law.
that I would like to address with respect to the supplemental brief and appendix. Through no fault of my brother, I did not receive this until Monday. In the supplemental brief of the appellee, there is one argument advanced here with respect to an act of the Congress, a law that was passed in December of 1970, entitled Family Planning Services and Population Research Act of 1970. Now, the gist of the argument here is that the Supremacy Clause of the Sixth Amendment now will make the Massachusetts law on this inoperative, totally inoperative, something of an occupation of the field argument. Now, I fail to see, and I repeat, I confess I haven't researched this, I haven't had the time, but in reading the preamble here to
That's wild
the
shit.
Congressional
I
Act to promote public health and welfare by expanding, improving, and better coordinating the Family Planning Service and population research activities of the federal government and for other purposes, I fail to see where the Congress intends here to occupy the field to the exclusion of a statute in Massachusetts that has been enacted under the police power. No, I fail to see the connection between the Supremacy Clause and the Congressional Act.
I thought, Mr. Nolan, that your strongest point really was that the police power was being exercised here by the state of Massachusetts to protect people from harmful substances at the hands of non-physicians. You don't abandon that, do you?
No, I do not, and that's treated in my brief, and there are quotations even from the Planned Parenthood.
Because for the longest time, till Sandra Day O'Connor, it was all fucking men, and all they're worried about is spreading their fucking seed around.
There's a warning that if there's any irritation, see your doctor.
Senator Tidings will give you an option if you would prefer not to split your argument today and tomorrow, 10 minutes today. We'll let you begin in the morning. What's your choice in the matter?
I think I'd prefer to please the court to begin now, Mr. Chief
Very well.
Justice, and provide my argument. I'd like to call the court's attention to the dissenting opinion in the Massachusetts Supreme Judicial Court. That decision was 4-3. If we found on page 26 of the opinion, I think it's a very fine dissent.
Well, which one?
That's on the Supreme Judicial Court of Massachusetts.
Yeah, but I think there are two opinions out there.
Now, this is the first when the case originally went up, and it was held 4-3 that the...
Yes, but there are two dissenting opinions.
Well, I was referring to the one by Judges Whitemore and Cutter found on page 26.
Yeah.
And I'd also, in
Nobody
regard
gives a
to
fuck about
standing,
your dissenting
I'd like
opinion.
to call the court's attention to the fact that the Supreme Judicial Court of Massachusetts implicitly recognized the standing of the appellee, and it's stated on page 26 there. The issue was never raised until oral argument before the First Circuit. And that when a man's in jail, convicted, serving time because of an unconstitutional statute, I fail to see how he could better have a standing to challenge the constitutionality
Okay,
of it.
that's what they're building
Now,
standing on.
May it please the court.
Old boy on the other
which,
side
I
wasn't
filed
setting
and
that up
which,
the same way.
My brother just referred to, describes with some particularity the legislative history and the background of the Family Planning Acts before the Congress of the United States. He failed to mention that we're talking about the Supremacy Clause here with respect to three separate statutes. The first one was the OEO statute in 1964, which authorized family planning clinics to be operated throughout this country, the contraceptives to be distributed to married and unmarried, rich and poor, without discrimination, to protect against the unwanted pregnancy. In 1967, that act was amended to specifically make it a program of emphasis and earmark funds in OEO that had to be used for that purpose. In 1967, we amended Title IV and Title V of the Social Securities Act to to provide that 6% of all funds appropriated for maternal and child care had to be expended in state family planning clinics for the distribution of information and contraceptives to married and unmarried alike, and the regulation specifically said that a state could not discriminate between married and unmarried. In Title IV, we specify that every woman receiving public assistance, that's every woman on welfare, had to have the opportunity, married or unmarried, rich or poor, to have family planning.
Is this a preemption argument?
Yes, this is the preempt. This is
Has that been made in any brief?
Yes, this is the whole substance of my brief.
Which is yours? I don't know
The one, Joseph D. Tidings, David Rutstein, number 70-17.
I don't have that.
Supplemental brief and appendix.
Go back to preemption. I wanted to hear more about that.
Excuse me, I don't have it. I'll get it.
I'm sorry, Mr. Justice
That's all right.
Brennan. I wish you did. But
Well, that's why I'm just not familiar with the preemption argument.
the fourth statute was the Family Planning and Services Act of 1970, which my brother referred to, which specifically, I might say, in the very first clause of the Act, Section 2, it is the purpose of this Act to assist in making comprehensive voluntary family planning services readily available to all persons desiring such services. The President, when he signed that Act, in two parts of his message, referred to adequate family planning services within the next 5 years to all those who want them. This Act merely significantly increased the amount of funds available. But clearly, Mr. Chief Justice, if the Massachusetts statute stands and the Wisconsin statute stands, they block the carrying out of this statute and of the 1964 Act and the 67 amendments to the Social Securities Act in Massachusetts and the state of Wisconsin.
It would be contrary to the federal act for a state to attempt to comply, to be consistent with the federal act if it said that all distribution of contraceptive materials will be through physicians.
It will
be available to married and unmarried alike, but our family planning clinics are going to be manned solely by doctors. No one else is entitled to dispense contraceptives.
I'm afraid that it would break down the whole thrust of the operation of the program for the reason that, first of all, you're talking about non-prescriptive and prescriptive.
It may not work, but would it be contrary to the face of the federal act, the federal regulation?
Well, it would be, certainly it would break down the whole thrust of the act. I would say if I were the administrator, I'd let them have the money.
I know,
because
but where in the federal act or regs does it say that the state may not use physicians solely, or that someone besides physicians must be permitted to dispense?
It doesn't say that anywhere. But the thrust of the act, Mr. Justice White, the thrust of the act is to provide these family planning services and contraceptives to the poor, to the unmarried mothers who need them, to provide them in clinics, and you just can't possibly afford to have a doctor in every clinic. And then when you tie on top of that, you make no distinction between prescriptive and non-prescriptive drugs, dangerous and non-dangerous drugs. In Massachusetts, it's perfectly all right, to sell a condom to a man if he says, an unmarried man, if he's going to use it for purposes of venereal disease protection. But if he's going to use it for family planning protection, then it's a felony. Now,
I know your time's running out, Mr. Tidings, for this afternoon.
That's not
I just
suspicious.
want to ask two questions. I've just got a copy of your brief now. I take it the state hasn't answered this additional question, has it?
no, it hasn't.
And I gather this argument was not made in any court below, was it?
That's correct, Mr. Justice Brennan. The right to make a decision to protect one's life or to protect one's health is a fundamental personal constitutional right within the penumbra, certainly, of the Fourth and Fifth Amendments and the Ninth Amendment as described in Judge Goldberg's decision in the Griswold case. I think the right not to expose one's life, or risk one's life to death, or to risk one's health by being forced to have an unwanted child is a constitutionally protected right. Now, the Massachusetts statute is arbitrary, capricious, and has no reasonable relation to a proper legislative purpose because it violates a fundamental personal right with no compelling state reason and with not a narrowly defined statute. And let me go one step further, if I might. There are two possible reasons for the Massachusetts statute. The first would be health. And yet how can you argue this is a health statute if you permit a married woman to receive advice and prescriptions from a gynecologist and you don't permit an unmarried woman?
Well, but is that an issue any longer?
Well, it's still an issue on the Massachusetts statute.
Well, on this particular case, though.
Well, this particular
Since
case...
there's no evidence in the case we find now about the marital status of the person to whom the delivery of this...
No, there was no evidence, but it was before a college audience. May it please, Mr. Chief
Well, but
Justice.
isn't the offense... I thought the offense was confined to the act of delivery to this one person.
Well, it is. The offense was defined, but the question of whether or not it was married or unmarried relates to
The
the
Chief
validity
Justice
of the
here
statute.
asking the question also dissented in
This
this opinion, by the way.
statute is inherently unconstitutional because there is no compelling state reason for it. And if you'll,
This is the
if I may
Baird court.
continue, I'll show some of the absurdities and the contradictions which put it clearly behind any justification either as a health statute or a moral statute. For instance, this statute...
I take it that's the ground that the Court of Appeals took.
That's correct,
That
Mr. Justice Brennan.
That the only possible justification could either be health or morals, and on the Court of Appeals analysis it was neither, therefore it was a completely void statute.
Exactly right. And let me take it a step further, Mr. Chief Justice.
Steve,
This
go
statute
touch some
says
grass, Pookie.
that you can't get a prescription for a non-prescriptive, non-dangerous contraceptive like MCO foam or a condom unless you go to a doctor, unless the sole purpose is for venereal disease. So the poor mother, let's say the poor married mother for the time being, without regard to the unmarried woman, she's not going to have $5 or $10 to go down to a doctor and get a prescription to go down and get a can of foam. I mean, that cuts off any opportunity for her to protect her own health. She might have had 4 or 5 children. It might be very risky for her to have another one. And yet this statute, it just arbitrarily discriminates against her. You got the situation where until 1966, Mr. Chief Justice, this statute didn't even hold out any relationship to health whatsoever. It said that no woman, married or unmarried, could receive a contraceptive from anyone. Now they put in the second statutory clause about a married woman and a doctor's prescription and so forth after the Griswold
We still
decision.
have it. It's called
But they tried to
spermicide
tailor it
now, Henry.
absolutely as closely as they could without any relationship to a health measure.
Well, we'll resume at that point in the morning.
Fine.
I have a mod in here. Can you do me a favor and block Steve because he's just irritating? Okay, guys, we're going to go on to the second part of this argument. Back in the day, a lot of these, there were 2 days or maybe even multiple days of oral arguments. This case is actually super short. It's only about an hour long. So we got, it looks like we got literally 15 more minutes of this case. We'll have a little bit of a discussion and then we'll go from there.
In number 17, Mr. Tidings, you may continue. You have 28 minutes of your time left.
Mr. Chief Justice, and may it please the court, yesterday afternoon when the court recessed, we were discussing the only possible interests or the possible reasons for the Massachusetts statute. And the first would be the health reason. And I was pointing out the absurdities of the statute and why it was not a health statute. And you recall I pointed out that it permitted a married woman to be examined, advised by a doctor, a gynecologist, but not an unmarried woman. It permitted a rich married woman with easy access to a physician to get all the prescriptions she needed, but it discriminated against the poor married woman. because it required her to get a prescription.
So let me talk about that for just a second. We see this a lot of times when we start doing beneficial restrictions. We see this when, look, I'll take it here just to make my point. Let's say gun safety classes sound good, right? They sound great. That sounds like a good idea. I agree with you. But if they're not free or low cost and you're mandating them and they cost about $200 each, you know who the person you're restricting is? Poor people. Fucking poor people. Poor people suffer because we make legislation that sounds good, or we make laws that sound good on paper, but then we don't see the fallout of what happens below. So that's just a highlight I wanted to give because I think that's something really important to talk about when we go into laws and things like that. It's just something to think about. Thank you so much.
For a non-prescriptive or non-dangerous drug or contraceptive. I might at this time point out to the court that the Massachusetts General Laws, Chapter 270, Section 3 at page 95, prohibits the giving away of medicines or drugs injurious to the user, and it incorporates the regulations promulgated by the Food and Drug Administration of the United States. And under those regulations, members of the court, there are certain contraceptives which must, in Massachusetts and every other state, be prescribed by a physician. For instance, the pill, the IUD, or the diaphragm. But the non-dangerous, the non-prescriptive drugs, like the condom, like the foam, like the vaginal jellies, they should be issued in Massachusetts like any other state. If the Massachusetts legislature had an interest in the health, they would have put it in here, but they protected against the health. This statute is purely and simply anti-contraceptive. Let me give you some of the patent absurdities. A married woman who's been separated from her husband for 3 or 4 years, she can go, be prescribed and get a contraceptive for family planning purposes, despite the fact she hadn't seen her husband for years, obviously for illicit purposes. But the poor married woman
God, what
doesn't have
the hell
enough
do
money
they
to go to
think
the doctor.
women are out
She
here
can't.
doing?
A bride, a girl about to be married, she can't go to a gynecologist and be prescribed a contraceptive, non-prescriptive or any other type, until after the wedding ceremony, and she dashes from the church to the gynecologist to the drugstore and back to the wedding reception. It's patently absurd. Now let's move on to the so-called moral aspect of the statute. And if you were to assume there was a moral reason, it would be, I assume, to restrain or deter fornication. But how could they permit, if that was the desire, how could they draw a statute which would permit a married woman who had been either separated, husband or wife had been away for 2 or 3 years in the process of a divorce and the divorce decree not final?
This is from
How could she go
1972.
down and get a contraceptive for family planning purposes, and the unmarried woman couldn't? If it was really a deterrent effect, why wouldn't you increase the statute from a misdemeanor? Fornication in Massachusetts is a misdemeanor, 90 days, whereas the selling of a non-prescriptive, non-dangerous contraceptive for family planning purposes to an unmarried person, that's 5 years. It's a felony. If they were really concerned with deterring illicit or premarital intercourse, they would increase the fornication statute from a misdemeanor 90 days, and they would enforce the law as it exists.
Is adultery also a criminal offense in Massachusetts?
It's my understanding it is. And yet this...
What punishment does that carry, you know?
I do not know.
More or less than fornication? You don't know.
I can't answer that.
This,
Mr.
of course,
Stewart.
It's wild watching
Adultery,
these old ones. They talk about fornicating and adultery
under the
so
law,
much.
This information is freely available to an adulterer or an adulteress, because by definition they're married.
That's right. So if adultery or the restraint of adultery is a purpose, it's completely vitiated by the language of the statute. The real thrust of the statute, may it please the court, is it's a holdover from the Comstockian days. It was originally and until 1966, it was designed to prevent any person, married or unmarried, from using a contraceptive in the state of Massachusetts. After the Griswold case, they amended it as narrowly as possible to try and come within the confines of the Griswold case. But it's not a health statute, and it's really not a justifiable.
Just real quickly, I want everybody to think about this. Now, War on Smugs is post this, but I want everybody to collectively think about something. When, and I'm just asking here broadly, has banning something prevented acts from occurring? They ban Smugs, not going well. They ban X, doesn't ever really take care of the problem. Like, I think it's like a traditional pattern in this country that we're like, we don't like it, we're gonna ban it. But the ban never takes care of the problem, and in some cases makes it worse. Yes, prohibition, culprit, thank you. That's what I was trying to think of. Prohibition still didn't work. We had speakeasies, everything else. Like, we have this pattern in this country of thinking if we ban X, problem will be solved. It never actually solves the problem because human beings, for the large part, are a creative fucking group, and we'll go around it if we need to. Okay, thanks so much. We'll finish this up.
A moral statute. May it please the court, I think the cases uniformly hold where you're dealing with a fundamental personal right. And I think there is a fundamental personal right here, namely the right of an individual or woman not to have an unwanted pregnancy which may be dangerous to her health or life. Then you've got to show a compelling interest, and it's got to be narrowly defined, and the state of Massachusetts meets neither of these. But even more, the Massachusetts statute violates the strong interest of society and the people of Massachusetts. And that interest is to protect the health and safety of a mother and a child. Be that mother married or unmarried, there is a strong interest to protect the health and safety of the child. There's a strong interest of society in Massachusetts to prevent unwanted pregnancies. And there's a strong interest in the state of Massachusetts to prevent unwanted and illegitimate children being brought into the world. And look what the statute does.
We're about to watch Roe v. Wade on Friday, and I want y'all to think about this. Look at these arguments. Now, Griswold was more scary, accurate on schmaga talking points, but they're still making these same arguments that we're having to make right now. This is in the 60s and 70s, and they're like, hey, shouldn't we make sure health and safety of child and mother are important? Should we make sure mothers aren't mothers aren't catching diseases or unwanted pregnancies? Because you know what? Just a hot tip. Unwanted pregnancies don't usually go well for the child involved either. That's a serious issue. Oh, hey, Law, hold on one sec. Sorry, I'm just ranting. You got anything?
Nope, you're on point.
Yeah, we're still redoing these arguments, and there's absolutely no reason we should have to be doing this. Women and children don't deserve to be brought into homes where the parents may not be prepared, may not be financially ready, or just frankly may not want them. Like, I don't believe children should be forced to be brought into that environment. I also don't believe that adoption is always the answer, because that system is so fucked up. I wouldn't wish that on most children. I'm not saying there's not success stories. I'm not saying there are not points where this changes and that child lives a great life. I'm not making any comment on what anybody should do. I just don't believe anybody should be forced to do these things. So we'll go ahead and finish up this argument if you're good with that, Law. Got about 10 more minutes.
Let's do it.
All right.
I mean, look at the damage caused by unwanted pregnancies. Take the mother to begin with. The mother, and I might say that in the state of Massachusetts, from the period of 1964, I think, to 1966 to 1968, 31% of the white children conceived in the state of Massachusetts were conceived out of wedlock, and 64% of the non-white children were conceived out of wedlock. Now, that's not to say they were illegitimate, because the illegitimacy rate was, I think, 6% in Massachusetts, but they were conceived out of wedlock. So far as any deterrent effect, it doesn't have any. But look at the consequences to the unmarried mother. First of all, she's likely, if she's so desperate that she can't have the child, she'll go to some quack abortionist, particularly if she's poor, perhaps inflict on herself some grave and serious physical injury. She's likely to die. If she does have the child and she's illegitimate, it puts her in a cycle from which she may never recover. You know, I think as well as I, the whole social problems of our nation with respect to the poor unwanted child and the welfare mother, but once she gets in that cycle, it's almost impossible to get out. Her whole life is committed from that point on. The health consequences to the particularly the poor unmarried mother are grave. You have a far higher maternal death rate from the unmarried mother than you do from the married mother. And let's look at the child.
That's actually interesting.
The
I didn't know
child
that
born
part.
out of wedlock. And the brief, may it please the court, by Mrs. Harriet Pilpel, the Planned Parenthood, from pages 20 to 26. Very explicit and cites all of the studies, HEW and elsewhere, which back up the facts I'm going to just comment on you. I'm sure that you know them anyway, but it's a very excellent presentation in this brief. But take the child. You've got the higher death rate of children born out of wedlock, higher premature births, a higher infant mortality in the first year, the greater likelihood of disease and mental retardation, and of course the saddest and really the most tragic thing of all, the greater likelihood of child abuse, child beating, and all the type of antisocial activities which contribute to making that child a ward of society from then on. Now finally, and may it please the court, it's the strong interest of society in the state of Massachusetts to prevent unwanted, illegitimate children from being born. Because these poor children, with many instances no father, many instances a mother, maybe 3 or 4 illegitimate children already, what chance do they have to make it in our life? They just don't have a chance. And if you look at the statistics in your institutions, whether they're mental institutions, whether they're penal institutions, you'll find that the prevalence of the unwanted child without the father is right up at the top. And that was the whole thrust and reasoning for the entire legislative program that the Congress has passed during the past 6 or 7 years, beginning with the OEO Act in '64, the 67 amendments to the Social Security Act, and finally the Family Planning Act of 1970. In May of this year, HEW announced in the state of Massachusetts that they're going to fund 4 major projects for low-income families in Lowell, Brockton, Springfield, and one other area in the state of Massachusetts under the 1970 Act. And of course the regulations say there that you cannot discriminate between married and unmarried. Now what happens if this statute is held constitutional? You're going to mean that in the state of Massachusetts and all 9 hospitals involved for low-income mothers, you're going to say sorry to the unmarried mother who might have had 4 or 5 illegitimate children already, but a next birth may send her to cause grave physical injury, even death, and you say, sorry, we can't prescribe to you because you're unmarried. I mean, that's...
I want to be clear if I have any like Gen Z audience or younger audience in here that may or may not know this. I mean, this is like getting to a little bit of a better time, but it's still part of a time where if you're having children out of wedlock, you're kind of coming off the market. It's not to say that like miracles didn't happen, but it was much less likely that you would find a marriage and get into it. I just want to put that in perspective for people who are like maybe thinking, oh, well, no, she's probably not going to find somebody. It's just a part of that time period.
That's patently against the best interest of the state of Massachusetts. It's against the whole thrust of federal legislation. It's an outdated anachronism from a Comstockian statute back in the 1870s, which has no business being on the statute.
Bro just said
today.
Comstockian. Just funny.
just make one or two other points.
Oh, come on, Berger.
I feel very strongly that what the Griswold case really held was what Justice Harlan said in his dissent back in Poe versus Ullman. And that is that there are limits to the extent to which a legislatively representative majority may conduct experiments at the expense of the dignity and the personality of the individual. Here we're not only talking about the dignity and the personality of the individual, you're talking about the very right to life and health, not only of the individual mother herself, but to the possible unborn child that she may have or she may have someday. And for these reasons, I would hope that the court would find the Massachusetts statute unconstitutional.
Thank you. I think you have probably about 5 minutes reserved for... No, you have not used up your full time. You have 5 minutes left.
Unless the court has some questions, I have nothing further to say.
Not. Mr. Nolan, you have 5 minutes left.
I have not have any time for rebuttal, but I would like to make one point. Chief Justice, may it please the court. My brother has alluded to Griswold. I think that if there's any case that way, while factually may be somewhat close to Baird, if there's any case that's distinguishable with ease, it's the Griswold case. First of all, Griswold dealt in the main with use. Permitted the doctors or the directors of the Planned Parenthood or the clinic down there in Connecticut to use that, but they were permitted to bring the suit withstanding because theoretically they might be aiders and abettors, I think the court said there. The point I'm making is that in Griswold, you're talking about use. Secondly, you're talking about married people exclusively. And third, you're talking about advice given by qualified physicians. Now, on the entire three bases here, the case is distinguishable from Baird, because in Baird we're talking about the propriety of a statute that bans contraceptives to the unmarried. We're not talking about use, we're talking about giving away or selling. And third, we're talking about people like Baird who are not qualified. So I think the Griswold, in no sense, aids the appellee here.
Thank you, Mr. Nolan. Thank you, gentlemen. The case is submitted.
All right. Thoughts, Law?
That was kind of a whirlwind. I thought the standing argument was particularly ridiculous at the beginning.
Yeah, he was kind of making me ask some questions. Like, I was like, okay, but can you briefly, because I kind of maybe understood a little bit of where he was coming from, because I guess maybe what they were targeting here dealt with, the single persons, and he wasn't affected by it. But to their point, he was charged. So I don't see why he wouldn't have standing. I was trying to understand, and frame that in my mind. And standing's not my best thing. So, I usually rely on you for, explaining that to me, because it still gets confusing from time to time for me.
Yeah, so, standing says there has to be an actual controversy and that you are a person that's affected, by that controversy. So I think the argument was he's not a person that's the target of this because he's not a single woman. But if he was convicted of the crime, then he's got standing to challenge it. But I think it may have been he may not have standing on an equal protection claim because he's not the party who isn't receiving the equal protection. He was just charged for violating the law by being the mechanism that which the party that's entitled to equal protection. Maybe if I'm stretching, it's just kind of a ridiculous notion to think that he was convicted of a crime but doesn't have standing to challenge it. That's one of the funnier things.
Yeah, that I perfectly agree with. Sorry, give me 1 second. Let's see what they actually said here, because I believe it was settled under an equal protection claim. It says Massachusetts law at issue violated the equal protection clause of the 14th Amendment by making it a crime for anyone other than a light. Well, see, this is a part I agreed with Berger on. I want to give it to that. By making it a crime for anyone other than a licensed physician or pharmacist to provide contraceptives, and by limiting access to such products to married people only. Brennan authored the 6-1 majority opinion of the court. It says Warren Berger dissented, arguing that a law legitimately regulated medical distribution of contraceptives, and Baird lacked standing to challenge it on behalf of unmarried persons. Now, that's what I'm curious about, is like the unmarried part, maybe, but since he was convicted, to your point, I don't know why he couldn't bring his case forward. But I guess if I'm looking at a reflection of that time period, particularly something akin to spermicide was what they were discussing in this case here, I could see Berger being like, well, maybe a doctor should be giving that out. I can at least step back and look at it this way, but the standing was interesting in this case. And this was only 7 justices. Maybe some people had unalive. That's maybe my guess. It doesn't say here.
What year was this?
72.
72. So I'm just thinking here. I think there was a vacancy and a retirement, and this is probably when I'm trying to remember. Yeah, I'm not going to try to rack my brain on this one. But yeah, I think in the 70s there was a death and there was a retirement for a while. So we had a 7-court. Or there may have been a recusal in this. I don't know. I'll have to look it up.
I just thought it was like, I was like, wait, what happened? Like, so between 65 and 72, I don't know. Douglas retired, or did he unalive on the bench? I thought he retired for some reason.
Yeah, Douglas retired.
Okay, so he left. But I mean, that's a 7-year gap. So I would have figured, I just don't know when he left. So maybe that, I don't know. And then Black's not on it either.
Yeah, Black unalived, I think.
Yeah. Maybe Douglas and Black. I'm not sure, but maybe. It's a huge time gap, so I can't say for sure. But yeah, no, this case is just crazy to me, because I mean, I feel like he made a really good point towards the end about, like, essentially you're letting married people choose whether they want to have these children, but single people don't have any say, and you're saying it's because of like adultery and fornication, we already have laws regarding that. So like, what does this do other than just harm people who are single at this point? I mean, I'm not saying people should be doing it, but they're going to do it anyway. Like, the rates are still going to be the same because people don't care. I don't know.
All right. I had to look it up because it would have kept me up all night. So Hugo Black was who resigned, and John Marshall Harlan died 6 days after Hugo Black resigned.
Man, that's rough. And then, Powell and Rehnquist weren't appointed by the time of oral argument. Okay, so that's what Rob said in the comments. Okay, that makes more sense now. I was trying to figure it out because I was like, it's unusual. So, not unheard of though. Wouldn't he have standing if he could help produce a child in the absence of access to contraception? Well, I mean, he was married at the time, I guess, is why they were saying like Law was saying he wasn't part of the group that wasn't receiving protection under equal protection.
Yeah, he was part of the essentially the the exempted class of the statute. So the argument for standing there is that, well, hey, if you're married, you're already exempt, so you don't have a right to challenge the law. But being convicted of it, like, if that's not grounds for standing and injury, I don't know what could possibly be any stronger than that.
Yeah, I mean, and I just want to reinforce this. So maybe this isn't really like a landmark case. Griswold is the landmark case, but this is the case that builds on precedent set by Griswold. Griswold said, hey, married couples can have the privacy in their own home to choose whether they want to like utilize these contraceptives. Eisenstadt said, why doesn't it apply to single people too? So I just want to reinforce here, that's why we're also doing Eisenstadt. Roe will be on Friday, Planned Parenthood on Monday, and then next Wednesday we'll be doing the Dobbs case, just to keep an update for the people in here right now. But is there anything interesting about how this builds on the Griswold case? Or I know you were pretty quiet during Griswold because you were working. Is there anything you wanted to chime in on there?
Well, I think what's unique about Eisenstadt is it actually found a due process protection, which wasn't what we saw in Griswold. Griswold had that privacy through the penumbra of the amendment. So what's kind of nice about Eisenstadt is it says, no, there's also a due process issue here too. So it built on Griswold not only by expanding the protected classes, but also by establishing this idea that that the right to contraceptives is also a due process issue by denying it to people.
I got you. I mean, Griswold, like, that was painstaking. That was about 3 hours of oral arguments. Those are rough. I had to cut some cases. I wanted to do some of the older cases because there was like 7, 8, 10 hours of oral arguments over multiple days. And I love y'all, but just not that much. But like, so I'm trimming down to cases that are about 3 hours or less. Not that it wasn't a good argument, it was just a long argument. But I think they kind of set a lot of this up in that previous one, whereas this one was just about an hour long. And I felt like Eisenstadt, which I'm guessing this it's a representative for Massachusetts, just fucking dog shit. Like, it wasn't a good argument. I don't know. Most of these people are drunk in court at this time, so it kind of makes sense. But like, it just wasn't a good argument. Really, the only thing he discussed heavily was the standing issue. Didn't get much out of him other than, nuh-uh, like, just because you don't like, the law isn't enforced doesn't mean you can't. Like, it's just nonsensical. Like, I didn't really see him making a strong argument for pretty much anything. That was my hot take on it. I did miss the first oral argument. Oh, sorry. Go ahead, Law. I apologize.
No, I think that's that's fine. That makes sense. I mean, I think their best option was to try to take it out on standing, saying that, the merits of the case don't matter because he has no right to bring the claim. But there may have been too many eggs in that basket.
Yeah, that's fair. Well, and I mentioned at the beginning of this, and like, I want to kind of reframe it again because maybe I'm wrong here, and in law, you can educate me if I am. We're talking about the early 1970s. This is a time maybe before even women could have their own bank accounts. This is a time where 7 years before this, they were deciding if married women, not single women, but married women and couples could choose to utilize contraception. I just want to think about the framing here. If a woman had somehow brought this case, I just think it would have fallen flat. Like, I don't know if I'm wrong there, but I don't think it would have gone very far. I don't think anything would have reached the point it was at. maybe.
Yeah, I mean, there's no way to know, but I mean, I think that the number of women attorneys at this point in history was probably in the uh, fraction of a percent, and then to have a female being the plaintiff or the petitioner anyway would have been very challenging because at this point in culture it's like those debaucherous women are just running around giving it out to anybody who wants, and we can't endorse them engaging in that type of behavior. But here we have a nice white man who was convicted of this crime, and my gosh, we can't let this affect white men. So I guess we'll give the rights to the ladies as well.
And think about even the question framing that was asked, like, towards some of these attorneys, like about adultery and fornication, blah, 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 blah. And this happened more in Griswold, but it did happen a little bit in this case. But like, I feel like it would have been a lot of like, well, they're just loose women with loose morals. And, to your point, like, we can't endorse them going. And like, that's why I framed it that way at the beginning, because I believe even if civilly, like, it would have challenged, right? Like, a woman would have been like, no, I deserve the right as a single woman to have access to contraception. She would have just been called a whore. Let's be so real. Like, she would have been called a whore. And so, like, I think it needed to be a male plaintiff in this case. Like, I don't like it, but I'm pretty sure that's what had to happen. It's just my hot take on it. First,
Yeah. Well,
what?
I mean, even Ruth Bader Ginsburg, when she was, doing equal protection cases, she initially started picking men as the people who were getting their equal protection rights. Now, tangentially, this also benefited women. One of her first huge cases that she argued before the Supreme Court was about I believe as caretakers. And while the vast majority of those were women, like hospital, nurses and elderly caretakers, her client in that instance was a man, because the law at issue had some misogynistic limitations on women in the profession, but she used men to take down that particular issue. I'll have to look up the very specifics. I've had a long day and very little sleep, so
I'm
my brain is
sorry,
not
Lol.
functioning at full power. But so even she realized that, well, hey, if we want to take down the system for protecting women, maybe we have to go to the heart of the laws by finding men that are adversely affected, because then other men will listen.
See, everyone can say whatever they want, but I believe that strategy makes a lot of sense because I just don't care. You have to use whatever's at your disposal to get the best possible outcome you want. Look, on the legal side, yeah, and on people's fifis and emotions, yeah, women all day. But like, if you're running a case and the better plaintiff is gonna be a man to achieve the result that you need, just do it. Like, I don't know. I think we get into a lot of back and forth about that today, and I'm not trying to like get into that question, but I like that strategy because you're using what's available to get the best possible outcome, and that makes the most sense to me. That strategy was used by the conservatives in Harvard. Yes. Yes, it was. And you know what? Like, I can't be mad at them for it. Like, listen, I cannot like the outcome of that case, but I can't be mad at people for using the best possible strategy to get outcomes that they want. Do I agree with that outcome? Fuck no. But maybe it like kind of gets everybody in a different set of mind. Well, they'll start doing that shit too. I'm sorry you had a long day, Lol. That sucks. I don't know that I have much more to go into about this because we kind of took care of it with Griswold on Monday, and then this one, we're gonna be doing Roe v. Wade on Friday. Let me see how long it is. I can't remember if it's really long. I think it was no, I didn't want to. No. Oh, there it is. Hold on. Roe, because Roe is 2 arguments. One is an hour. And then there's a re-argument. That's also an hour. Well, if there's a re-argument, do I need to listen to the original one, though?
Yeah, probably.
Okay. So that's a longer one. It's probably going to be about 2.5 hours, I would say. Maybe I should move it to Monday. Nobody wants to do that on Friday night except for me because I'm the biggest nerd possible. Or maybe I'll watch one on Friday and then we can move it up from there. But yeah, we'll go into Roe on Friday, but and that's going to be where we're getting into our abortion cases with Roe, Casey, and Dobbs. So we watched our 2 major contraceptive cases, which is Griswold and Eisenstadt. Then we're going to go into Roe, Casey, Dobbs. Roe kind of set up, that you have a right to abortion. Casey rolled it back, and then Dobbs said, fuck y'all. That's not exactly what it said, but you get my meaning. But I kind of want us to keep an eye on how women are discussed in these cases, particularly Roe, because man, Griswold, if you haven't watched any of my other YouTubes, man, go watch the Griswold case when we were watching it the other day. It was scary how similar the way that those talking points were to how the conservatives talk about women today. I almost think that they use it to prep for when they come into arguments to just shit all over women. It was pretty scary. Said I watched Obergefell, was horrified the way they did it. Yeah, Obergefell's a case we're might do next month. I'll be on vacation a little bit in July, but I got it I have like over 60 cases. I put them in groups. And then I think with Obergefell, we'll do Lawrence v. Texas. And I had a few other ones I wanted to do. Law, I'm going to let you go so you can get your work done and go to bed because I know you're like tired. We'll go ahead and end early today. Did you have any final thoughts?
No, good job. It might be worth breaking Roe up over 2 days to, give a chance to digest and maybe get some buzz from people talking about it. But yeah, you do you.
Maybe we'll do it. Maybe we'll do. We'll figure it out with Roe. We may take it to next week, and on Friday we may just chill. So everybody, just watch my stories. If you don't follow me, follow me. Watch my stories because when I'm going to do a case, I'll put it up there. We may just we'll look at the timing on that. I'll talk to Law about it when he's not exhausted. But anyway, all right, guys. I hope you all have a good night. Law, thank you for coming up and kind of explaining standing to us and going through a little bit of this with us. I really appreciate you. And everybody.
Anytime.
All right, guys. Bye. Jensen.